on our social media platforms. The hashtag is KTN News Center. You can also tweet me directly at Michelle Ngele, or tweet us at KTN News. Now, the Kenyan court system has over the years been burdened by numerous cases that sometimes span for years before their conclusion. The Judiciary, alongside the Nairobi Center for International Arbitration, are now pushing for the adoption of alternative dispute resolution mechanisms in Kenya. This, they hope, will cut down costs incurred in litigation processes and unclog the largely overworked Kenyan court system. Out-of-court processes are usually take shorter time depending on the cooperation of the parties involved.
And required of counsel to proceed with their cases, we would, to a very great extent, reduce the number of what I consider myself to be totally unnecessary adjournments.
The appeal for the alternative dispute resolution in modern Kenya is that it draws from the traditional African practice of conflict resolution, whereby the parties had control over the process and it allowed for creative solutions to disputes.
All right, well, let's take a look now at some of the main alternative dispute resolution methods available in Kenya. The Kenyan Constitution 2010 there takes a look at those cases under Article 159 of the Constitution there, which says, in exercising judicial authority, courts and tribunals shall be guided by the following principles and alternative forms of dispute resolution, these including reconciliation, mediation, arbitration, and traditional justice resolution mechanisms shall be promoted. Well, alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution, shall be promoted. And moving on there, Clause 3 says these must be consistent with constitutional principles and values. All right, so these are some of the pending court cases nationally, and this was as of December 2016, 505,315 cases, and out of those, 360,284 of those were over 5 years old, which is quite a long time. Like I mentioned earlier, out-of-court resolution of disputes tends to take a shorter time. And then we have the Milimani Court of Nairobi there, which has 22,203 cases in the family division that are pending, and a further 5,448 cases in the commercial division. We also have other pending court cases in Nairobi, this as of 2018 there. We have Nairobi region with 2,532 pending cases. In the Makadara court, there are 1,164 cases, and in Milimani court, 417. All right, there we go. So let's take a look at the options then when one wants to turn to alternative dispute resolutions. Several methods are available in Kenya, like negotiation. We also have reconciliation and arbitration. And we also have MEDARB there, which is a hybrid between mediation and arbitration. All right, and other options there are a hybrid between arbitration and mediation. You have arbitration itself, and then litigation or the trial itself. All All right, well, this is a discussion we're having in studio this morning. Joining us for more on this conversation, we have Elvis Sobok, who is a practicing lawyer with a special interest in arbitration. Many thanks for joining us on News Center. We also have a reporter, Famo Mohammed. She'll be speaking to us about a few stories she's been doing on the ground there when it comes to arbitration and alternative sources of arbitration. Many thanks for joining us, Famo, on the show. And last but not least, we have Mary Cheriot, who is a mediation expert and management trainer with a keen interest on mediation. Mary, many thanks for joining us from Eldred. Perhaps let me begin with you, Elvis, now that you're with us here in studio. The question we're asking Kenyans this morning is whether they prefer the court process or alternative mediation. In your practice as a lawyer, what are Kenyans opting for?
Thank you for having me here. It's not quite easy to tell what Kenyans might be going for, but the truth of the matter, as you've seen it on the TV there, is that there are so many cases that are being filed in court.
Right.
There are certain arbitrations that are going on, but whether Kenyans are opting for arbitration is not easy to tell unless research is done into that area. What I can say for a fact is that Kenyans are filing cases. There are many cases in courts, all sorts of cases. This could be because Kenyans are not aware that there are alternative ways of resolving disputes other than filing cases in courts, or probably in certain instances, Kenyans are aware that there are alternative ways of resolving disputes to litigation, but are weighing which of the two is more effective for them.
Right.
There's need for greater research into this area of dispute resolution and the very concept of alternative, because if you say alternative dispute resolution, why can't litigation be an alternative mode of dispute resolution and not arbitration or mediation, or a hybrid between mediation and arbitration.
Right.
So there's need for greater and focused research into this area and into the reason why Kenyans in the very first place file so many cases, or rather the reason why there are so many cases in courts, whether criminal or civil or so on and so forth. There's really need for greater research into this area.
All right.
Yes.
All right, let's bring in Mary Cheriot. She is a mediation expert joining us live from Eldred. Many thanks for joining us, Mary. There are many benefits of mediation, but like I mentioned earlier, many of these methods must be carried out in means that are consistent with the constitutional principles. What are your thoughts on Kenyans embracing alternative mediation as a means of dispute resolution?
Well, most Kenyans have not been aware this far that it's been possible to use mediation, even though in some way, historically, Africans used negotiations, conversations, and dialogue between especially elders and who sought to resolve disputes. But currently, definitely, like I think the other person has mentioned, that there has been a lot of dependency on litigation, partly because people are not aware that there is a better alternative of mediation where people dialogue and are assisted by an independent, impartial person to bring out what is important for them, what their concerns are, what their interests are, so that they can agree on how to move forward over a matter that is in dispute. But those that are getting to hear about it and understand it are embracing it because they find that there are benefits. One of the biggest benefits is the fact that mediation has been able to resolve matters much faster than litigation because it depends on the two, on those that are in dispute, not necessarily waiting for court procedures and court time allocation and so on.
Well, what would be the effect or the benefit on the judicial system should more Kenyans embrace alternative forms of dispute resolution, especially when it comes to the backlog of cases?
The benefit to the judiciary is enormous. because if Kenyans should embrace mediation more as a means of resolving disputes, it means that many more matters will be resolved, many more disputes will be resolved amongst the people or within communities instead of filing cases, because the continuous filing of case for every dispute, every conflict is the one that leads to the creation of a huge backlog, because the number of cases as compared to the number of those in judiciary becomes so big that it is difficult to keep up. So the judiciary would definitely benefit greatly. The more mediators we have, the more qualified and certified mediators we have, the better it will be for the judiciary in serving the Kenyan people in resolving their disputes.
Right. You personally have a keen eye on mediation as an alternative dispute resolution. What would be the process for Kenyans to engage in mediation?
Getting mediation for matters that one is involved in can be done in different ways. One, it's possible to get a mediator or to have a mediator referred to one. Should you, for example, have a dispute, it is possible to talk to someone like me, whom you know is a certified mediator, or you could talk to someone else who is aware. There are many media houses that have interviewed several certified mediators, and they may be able to give you leads. And if you know a particular mediator, you can actually approach them and let them know of the matter that you have or the dispute that you have and invite them to come and help you resolve it. Another way, of course, is also to go to the mediation accreditation committee houses or at the Supreme Court and ask to be given a name or names of mediators that are registered, that are accredited, who can then be able to facilitate the mediation process for parties that are in dispute. There could also be other ways in that you may know of institutions or firms that are training mediators. Like, for example, I am out here in Eldoret because we are involved in training of the top management of Moi Teaching and Referral Hospital, or MTRH, in mediation where they want to gain skills. And if you come to us, we will tell you of people whom we've trained, who are already practicing, who are capable and competent of resolving the disputes that you may be facing. Or we could offer ourselves, we too are practicing, and so we can offer ourselves to mediate on matters that are facing one.
And we'll be discussing the constitutionality of this, because I believe that is where many would feel then that the legal process has not been included. But let's come back to studio and speak to Famo Mohammed. She is a reporter here on KTN News. Many thanks for being with us here, Famo. And many different communities have different ways of alternative dispute resolution. The Islam community also has its own ways of dispute resolution. Talk to us about that.
So I've been spending the last month or so doing an investigation on this alternative method of resolution in the Somali community. It's called maslah.
Right.
So maslah translates to a reconciliation or a peace offering. So essentially, the community prefers using this form of resolution where elders come together and solve the problems. I'll give you an example. So these are issues of land conflicts, divorce, clan conflicts. They'd rather solve these issues within the community than perhaps going through the judiciary process. And I think that's where the controversy arises. Because in cases of criminal offenses, how can a community like that justify murder and try and resolve it with the use of maslaha, rather than impeding and going through the judiciary process?
All right, let me just stop you there then and listen to a GA Women of Parliament, women representative there speaking about maslaha.
Maslaha is a problem in one way, and it's not a problem in another way. For us, the people who comes from the northern and Somali, people who practice Somali culture, maslaha has helped us a lot in terms of dispute resolutions. It's an alternative dispute resolution mechanism. In terms of land disputes, if there is a conflict among clans, if there is, small offenses, it helps. in terms of negotiations, whether it is in terms of resource negotiations or any other. Maslaha actually helps.
All right, that is a women representative of Wajir County. They're talking about Maslaha, an alternative method of dispute resolution within the smaller Islam community. Fama Mohammed is still here with us. Now, she talks, just like you were saying, about the method itself being misused, so to speak, by society. Expound more on that.
Well, I think this method has been used for generations to come, essentially. But essentially, in this modern age, where issues of rape are addressed, murder and criminal offences, the community still prefers to use maslaha to resolve these issues. So now, how can you justify murder? Like, how are you going to compensate a family for the murder of, their son or their daughter? So this is where the controversy arises, because the community just prefers to resolve these issues. Perhaps in the past, it could have worked, right? But in this modern age, it is impeding with the judiciary process. So that's why you can see the women rep, Wajir women rep Fatma Getty is addressing such issues.
All right, what that brings in then, Elvis, is that many may feel that when you go for alternative dispute resolution, then justice, their deserved justice, may not have been served. Let's talk about arbitration, because you have a keen eye on arbitration. How does it work as a method of dispute resolution?
Well, the first thing is that arbitration is preferred by parties who prefer to have autonomy over how their disputes are resolved. So there's a greater party autonomy in deciding to go for arbitration, choosing your arbitrator, deciding on the rules of arbitration, the place of arbitration, the kind of award that you could have, the law that is going to govern the interpretation of your contract, and so on and so forth. So the first thing with the arbitration is that you've got to choose freely to go for arbitration. But in theory, at times, free choice is really not there. What I mean by that is, if you're buying land, for example, say you're buying a property somewhere, at times as a purchaser, you're presented with a contract which has got an arbitration agreement. You either take it or you leave it. So to the extent that the clause is already in the contract and you have to take it or leave it, it may not be free choice. But there are those other instances where there's truly free choice. In commercial transactions, you negotiate into a contract with another party and you decide to have an arbitration agreement there because you want to resolve your dispute by way of arbitration. That's one way of going to arbitration. The theory is that arbitration is less costly, is effective, is less time-consuming as opposed to litigation. In certain respects, that is correct, but not in all respects. And part of the problem has been that the narrative for a very long time has been that arbitration is less costly, is more effective than litigation. So go for arbitration, but not necessarily, because you find that certain problems that affect litigation also affect arbitration, could even be worse in arbitration. So the idea here first is for parties who want to resolve their dispute, whether they are going to the court or to mediation or to arbitration, to have good faith. Good faith is very important, and an understanding that they need to cooperate towards settling their dispute. That is very important in all respects, whether it's litigation, mediation, or arbitration. Without good faith, the system doesn't work properly.
But there is an arbitration act in the country. Now take a look at instances in which the court may intervene when it comes to the arbitration proceedings. Let's just take a look at that on our super wall. And one of those is the determination of the enforceability of arbitration agreements. And we also have the granting interim measures of protection, which is quite an important measure when you're talking about interim measures of protection. How can the court come into that?
All right, this interim measures of protection can, in the first place, be granted by the arbitrator himself or herself. The two of you or three of you, the parties to the dispute, before the arbitrator could apply to the arbitrator that they want some interim orders, and the arbitrator may give these orders or fail to give them. It is based on that you can make an application to the High Court, to the courts, for the courts to, if the arbitrator fails to give it, for the courts to look at it and give you again. So the court comes in that respect. The court plays a big role. You see, you can also file a case in court while you have an arbitration agreement without disclosing in that case in your pleading. Honest pleading, very important, that there's an arbitration agreement. If a party raises the issue of arbitration while you're in court, the court is duty-bound to stop the court process and refer this matter to arbitration so that the arbitrator can get an opportunity to look at the facts, to make his determination, and then this is brought back to the court. With respect to, if we go back to some of the problems, because my understanding of this discussion today is that there's a need for greater participation in alternative disputes resolution than litigation, and understand alternative to be anything other than litigation. But I go back to emphasize the point I made earlier, which is that it is quite important for parties to a dispute, regardless of what mode of resolution of that dispute they choose, to get into this process of dispute resolution in good faith with an understanding of fairness. That is, that what is fair to everyone is fair to me. That the best system is a system that is fair to everyone. If you got that understanding of good faith and a willingness to cooperate to resolve your case with the other party, then it will not matter which mode of dispute resolution a party chooses, whether it is litigation or arbitration, they will all be good. All right. So let's take a look at how else then the court can come in and intervene in arbitration proceedings. Then one of them is also setting aside the appointment of an arbitrator, or also appointing an arbitrator where none has been appointed. The court can also come in and assist in the taking in of evidence during the arbitration process as well. Let's just put that up on the super wall so that our viewers can see that this morning. The court can also come in and assist in removing an arbitrator or setting aside of arbitral awards in the cases where the concerned parties have a problem with the arbitrator that has been chosen. And we also have the court that can come in, in hearing and determining appeals, where the right of appeal from the decision of an arbitral tribunal lies to the court. And that's an important one, Elvis. Again, when it comes to appeals, when you're using arbitration as a form of method or dispute resolution, how does that process work? Well, the process of appeal works in this way. One cannot appeal in all respects because arbitration agreement by its very nature is an alternative way of resolving a dispute, so it's meant to be final, unless the parties in the arbitration agreement say that there's a right of appeal on this or that issue. But the rules and the laws themselves say that one can only appeal against an arbitral award, that is the award itself at the end of it, if one can prove misconduct on the part of the arbitrator, gross bias on the part of the arbitrator, corruption, fraud on the part of the arbitrator, and probably excess of jurisdiction. Gross excess of jurisdiction on the part of the arbitrator. So it's not in all respects that one can appeal. That's the finality of the arbitration agreement. So one is not meant to get its way back to the court system after it's chosen to go through the arbitration, unless there's good cause for it. All right. Let's take a look at some of what Kenyans are saying in terms of dispute resolution options. This is citizens from Nyeri County.
Afadhali kwenda kotini vile wale wazee wa kijiji mara nyingi wanaangalia yule mtu wako na kitu, so wanaonekana watakuwa compromised. Lakini koti ni afadhali vile magistrate au judge hajui nini na hajui mimi kutoka zamani.
Ile kitu mzuri ni kusolve hiyo mashida kwa nyumba, sio haja ya kwenda kotini. Juu ukienda kotini yule labda unashtaki awe na pesa, hata ukiwa ni wewe umekosea labda utafinyiriwa tu. Wewe kama huna pesa haina haja ya kwenda kotini. Jaribu kusolve hiyo mambo kwa nyumba.
Kwa tumekosana na ndugu yangu, so mimi niliona tukaita wazee wa kijiji, tukasolve bila kwenda kwa koti. Juu tungetumia koti, naona hii shuki ingeisha.
Mabusi ya wenyewe inaingia kwenye shamba la wenyewe na ikakula vitu yote ya shamba. Sasa badala ya kwenda kotini au kwa chief, tukakaa pamoja, tukaambia mwenye shamba aweke fence. Na akaweka fence, sasa hakuna ng'ombe zinaingia kwake. Na hiyo kesi kaishi hapo.
Seems to be a lot of Kenyans who are opting for alternative dispute resolution. They will be coming back to the issue of arbitration. But let's bring in Mary Cheriot, a mediation expert there, joining us live from Eldoret. Mary, let's now focus this then on the broader aspect here. There are many options of alternative dispute resolution. What is the underlying problem as to why Kenyans are not opting for this?
I think the biggest, like we said at the beginning, is actually lack of awareness in that many people, many Kenyans have for some reason, for a while now, been mainly dependent on litigation or going to court as a way of resolving disputes. So the need to create awareness in the fact that there are other ways is really important at this particular point. The other one is that for some reason it seems to have developed, a culture seems to have developed of wanting to win at all costs, where each person who is going on a matter of dispute, who is going to seek for assistance, is actually looking for an opportunity to win. But unfortunately, that doesn't help to resolve disputes, because what happens when a matter is decided in court, for example, in favor of one, it immediately creates a very bad feeling in the other person. So we create winners, and we also create bitter people. And therefore, we generally create a culture of embittered people. And that is why we are saying, really, that the way to go is to use methods that help people talk, dialogue, come to agreements that they determine themselves, not necessarily that are imposed on them. And that is one of the biggest benefits of mediation. So I think the need to create awareness on the benefits of the other methods is critical. For example, mentioning benefits, like in the case of mediation, that is able to resolve matters reasonably fast. I mean, there have been matters that have been lying in court for more than 10 years, going to 20 years, that have been resolved in 2 months. And you know, that releases resources that were otherwise frozen for years upon years to become available to the family for use. And that's a big benefit. You would think of a woman who gets widowed and her property, there's a fight over the property that is left behind. And she can't access that property because the matter goes to court, and maybe she has children to take care of, but she has to wait until the court determines. But if that matter, for example, is handed over to mediation, chances are it can be resolved, or it could be resolved within a much shorter time, therefore releasing the resources for those for which really they were created, those that are left behind. So I think the need to create awareness is very critical. Some of us are actually really involved in that creation of awareness. We, for example, for us at Dispute and Conflict Resolution International, we are in the process of organizing for a national conference in July on mediation. We hope to have it in Nairobi. And with all this, what we are trying to do is to create an awareness amongst people that it is actually possible to use other methods, and particularly mediation, for resolving of disputes. And I think it will help. Once people know, they will actually come and use it.
Many thanks for speaking to us. That is Mary Cheriot. She is a mediation expert. It's a conversation that needs a lot of time to come back from. Let me just come to you, Elvis, as we finish up, because Farmer brought in the issue of Masla, and we'll be speaking about the feature, the Farmer, and the investigation that you've been doing. But from that, we see that there are alternative methods of dispute resolution within the smaller communities that have quite a lot of controversy surrounding them, like masla and rape in the Islam community. How then can the court come into this process and ensure that justice indeed is served?
Well, that's a very important question, because the role of court as a social institution is to dispense justice. Just a small point on arbitration. One cannot arbitrate over something that is illegal, so arbitration might not work in those respects where a crime has been committed and that kind of thing. But traditional ways of dispute resolution and dispute resolution using the churches, particularly in family issues, marriage issues, using a church to try and resolve dispute resolution. I'll give you an example. The Marriage Act of 2014 provides for ways of conciliation before a person applies for petitions for a divorce, so that at least a marriage can be salvaged if it is a marriage that was celebrated within the context of a church or a church ceremony. Well, the courts are actually helping. In the social media lately, I've seen certain cases that have been, judgments that have been posted there. It's been running around in the social media of courts actually supporting traditional ways of dispute resolution, whether it is brewing of muratina or changa, and someone is taken to court, hauled before courts for some crime, and the court saying, no, it is not a crime, because the Constitution itself actually recognizes that being Kenyans, we come from different societies, communities, with different traditions, some of which are not bad and should be encouraged to thrive and develop, because that is one way of making sure that a society is harmonious. So you find courts coming in to uphold certain forms of dispute resolution that are undertaken in the traditional setup by the village elders or by the church. One might say that church is not very traditional, it's a colonial concept, but yes, they do that. Chiefs, for example, play a very big role, chiefs in the local areas, assistant chiefs, in dispute resolution, and this is very important. The courts themselves recognize that chiefs play a very big role in dispute resolution. So the courts are helping in that respect. Of course, one might say that the courts are self-interested in this, in the sense that the courts are also trying to reduce backlog of cases and to encourage parties who might otherwise come to court to think of other ways of resolving their dispute, so that you don't force the hand of the judge to resolve a dispute that the judge need not resolve. Because as earlier spoken by my co-panelists there, mediation helps. It is that people are not aware that mediation may help, but mediation helps. What is important about mediation and these other things, these other ways of resolving these disputes other than going to court, is that you maintain your relationship after the resolution of the dispute. Courts, the judgments of courts are rarely fair to everyone, because it's winner take all, or there's a loser there. And at times you find that it's not the best way of resolving a dispute. When you're left with nothing, you went to court expecting that you might get something out of it, and it destroys relationships. So that is one thing that the courts are also recognizing and helping to avoid, by telling parties that please think through before you file a case. But if you go to file a case, make sure that you've attempted to resolve it. Yes.
All right. Well, that's an interesting approach there. Famo, let's come back to Masla just as we wind up very briefly. Talk to us about this investigation and what it yielded.
Well, I think Elvis said something really important. It's about trying to find fairness, right? So within the bigger perspective, there are like loads of communities and ethnic groups in Kenya, and essentially, you know, for these minor issues, you know, like divorce, land conflicts, clan issues, you can use maslahat to resolve those issues, you know. Community elders, chiefs coming together and helping the families, like, keep those ties. I think that's the importance of the name Maslaha in Somali, translating to reconciliation. So essentially, my investigation has looked at Maslaha and whether Maslaha is a problem in trying to hide criminal offenses and not holding culprits accountable. So that's kind of where I'm looking into finding. And with all of my findings so far, I'm seeing that maslah is a solution. Similar to what Fatima Getty said, maslaha is a great solution for minor issues. However, it should not impede with the judiciary process.
All right, so the weight then of the issue being handled again would also influence the choice of method of alternative dispute resolution. Well, Famo is just back from the field and is producing a long-form investigative report on the controversy, or the controversial use rather, of maslah in rape. Here's a sneak preview of a piece that will air in the coming days.
Miaka 50 years I was raped.
Hiyo ni wazimu. Hiyo si kitu ya kawaida. Msichana ya miaka 4 ana nini ya ana uwezo gani ya kustahimili mwanamume?
Tunaweka hapa police station, napeleka wajie, nafungwa baada ya siku 20. Tunaona hiyo watu iko ndani ya town.
This is a story about hopeless living under the shadows of community and clan bigotry.
All right, and that will be coming to you in a few days. But that brings us to a conclusion on our conversation this morning. I want to thank our guest in studio for joining us, Elvis Sobok. He's a practicing lawyer with a keen interest on arbitration. We've also had Mary Cheriot, who is a mediation expert, joining us live from Eldred, and Famo Mohammed, our investigative or features reporter here on KTN News. Do stay tuned for that feature by Famo Mohammed in coming days. We're going to take a short break on News Center, but when we come back, we'll be speaking live to our reporter Willie Lusige, who will be joining us with an update on the Mount Kenya killings. Do stay tuned for that. This is News Center.